Kathryn Dugan. I'm representing the state of Florida in this case, along with Georgia Cappleman. I know y'all are tired, hungry. It's 5 o'clock. I'm going to try to be really quick. I want to go over just a couple of concepts with our new folks to see if y'all have any strong feelings about any of them. But if any of our original folks that are here in the first and second rows, if you have anything that you want to add, change your answers on, an idea that popped into your head, just raise your hand and let me know. All right, so Ms. Cappleman talked about reasonable doubt. The state's burden in a criminal case is we have to prove the case beyond a reasonable doubt. We have to prove a crime was committed and that Mrs. Adelson is a person who committed that crime. And we talked about the definition of reasonable doubt. It's not a forced doubt, something you're making yourself believe. It's not a speculative doubt or a possible doubt. We could all sit around and come up with maybe this happened, maybe that happened. The doubt that you're having has to be reasonable. Does everybody understand? Okay. And we talked about why it's beyond a reasonable doubt, because it's impossible unless you're a witness to be convinced beyond all possible doubt of anything. Okay? Hearing that though, do any of our new people feel that I understand what the burden is, but it should be higher than beyond a reasonable doubt? I would personally have to be convinced beyond all possible doubt in order to reach a conviction in a criminal case. Does anyone feel that way? First or second row or third row? Okay. And who decides whether the doubt you're having is reasonable to believe, given all the evidence in the case? Who decides that? You guys do, right? Okay. And you do that thinking back on everything you heard in the case, using a totality of the evidence that you heard. We had a couple of people in when the defense was asking questions that some of you mentioned, Mrs. Adelson, maybe she did something to be charged, but, and while I understand what you're saying, that's not something for you to consider in a criminal trial. The law is that she's innocent until proven guilty, and that it's the state's burden to prove the charges beyond any reasonable doubt to you all through the evidence you hear from the witness stand. Does that make sense to everybody? Okay, so that's something that should not be considered. The evidence in the case and whether it meets that burden is what y'all consider, okay? And speaking of evidence, if you're picked as a juror, your job is going to be to focus on that evidence. That could be physical evidence, like a picture you can hold, or it could be testimonial evidence. That's going to be a lot of what y'all are hearing. People are going to be coming up to the witness stand that may have knowledge or information about the case, or people who investigated the case. You're going to be listening to the words that they say, watching their body language, so that you all can determine the facts of the case and what happened here. And then you're going to apply what you've heard to the law Judge Everett gives you and render a verdict. One thing that Ms. Cappleman touched on is that it's not the jury's job to decide the sentence. Knowing that, though, is there anybody who feels that I just would not be able to reach a verdict if I didn't know what the sentence is going to be? Anybody on the first row or second row or third row? Okay. Another thing I thought about is, obviously this is a first-degree murder case, and when you hear first-degree murder and you talk about possible sentencing, sometimes people think death penalty. That's not something that's on the table in this case, or could ever be a possible sentence here. So just want to make that clear for everyone when we're talking about that, okay? And I didn't see anyone's raised hands, so everyone is okay leaving the sentence up to the law and to Judge Everett, and you all decide the verdict, right? Okay. We talked about the principles instruction. You guys heard the law on that, even though maybe you're not the person who pulled the trigger in the bank robbery example that Ms. Cappleman did with the court reporter. If you had the intent that trigger be pulled, if you did an act or said some word that encouraged or assisted the person who did the shooting, then you can be considered a principal and treated as if you were the person who pulled the trigger and did the shooting. Does that make sense? All right. Now, okay, so I have another example that if you are, let's say during a football game, if a quarterback throws a pass to a wide receiver, okay, the wide receiver catches it in the end zone, it's a touchdown. If scoring a touchdown is a crime, Who is a principal to that touchdown? What do y'all think? Let me see. What do you think, Ms. Tolbert?
After what you just said, I'm confused. Like, I will say, I guess the guy catching the ball would be the one in trouble.
Wide receiver? Catch the ball to make that touchdown happen. He wants it. He's running, trying to catch it. You don't know?
That's tricky because it just confused me.
Okay. Is he doing an act or saying a word to assist that touchdown?
The person blocking or the person throwing the ball?
The person blocking.
He's doing his position. He's doing what he's supposed to do with the game. I'm confused.
Okay.
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 It's confusing.
I gotcha. Okay, so if the person blocking is doing an act of blocking so that the touchdown can be scored, and he wants that touchdown to be scored, is he a principal?
Would be because he's allowing it to go.
Okay. Does everybody agree with Ms. Tolbert there? Oh, she's.
Figured that you guys have other places you would like to be at this hour, as do we. Did everyone hear when I discussed the concept of implicit bias earlier?
Yes.
Yes? You all agree that you will make a conscious effort to be aware of that if you were selected as a juror and in your deliberations?
Yes.
Okay. By a show of hands for the new ones, anyone in a leadership position? Okay, we got quite a few. Mr. Oh, I'm sorry. Okay. Do you have staff that work with you?
Yes, I have two staff that work with me right now. That I've been owner operated for the last 13 years. So I've had a staff of 10 at times.
Okay. How do you, when you're a leader, try to draw out other people so that everyone is involved in a conversation?
You want to set up a process or a system to do that. You want to set up a process or system to do that. I think it's the easiest way out front to get everybody drawn in, kind of let everybody know. Let's have a system where we delegate. Everybody has a time to speak or give their thoughts, and then we collectively come back.
And so, as a leader in that type of scenario, you would make sure that everyone's voice is heard.
Yes, absolutely.
Okay. Even the ones that don't really want to speak.
Everybody has to be heard.
Everyone has to be heard.
Correct.
Okay. Ma'am, what was your number? No. Yeah, 28. Thank you. I didn't have it written down properly. You raised your hand when I asked about leadership position. How do you avoid a misunderstanding?
To clarify, I'm hired now, but I was in leadership.
Congratulations.
Thank you.
When you were working, and it would apply now too, how do you avoid misunderstandings when you're in a group setting?
Repeating what somebody said, making sure there's active listening and active communication. Going back to people and making sure that they repeat what's been said or repeat the question.
So in other words, not just listening, but comprehending. Okay. Does everyone agree with that? Yes. For those new individuals, would you agree that we're all human, we make mistakes?
Yes.
Yeah.
That includes law enforcement, includes the state. Number 32, you said that your family was recently victim of a home invasion type of incident?
Yes, sir.
I'm sorry?
Yes, sir.
Is that something that, I assume that you all were home?
We were not. We were actually out of town and our cameras picked it up. So we called law enforcement as soon as we saw it and they came out and did their thing.
People arrested?
Yes.
Okay. Well, I'm glad that you guys weren't home.
Yes, me too.
Did you do anything, heighten security after that?
I mean, we already had things in place for security, so we haven't taken extra measures on top of what we already had.
Is that something that you think about on any sort of regular basis?
Sure, yeah, of course.
Now, would that or could that be something that you would think about if you were selected as a juror in this case?
No, I think they're two different situations.
Number 29. Said that your uncle was murdered.
My wife's uncle.
Your wife's uncle, I'm sorry. How long ago was that?
About 10 years.
10 years? Was that here?
In Greenville.
In Greenville.
So, 30 minutes away, east.
Were you all close to him?
I guess she was because it was her uncle, but not really. He was kind of in and out as far as just maybe an odd uncle. I don't know. You know, he was there, but I don't know that he was like super close. But the whole incident was a shock. But I mean, I don't know that I never really knew him to know like if he was involved, if it was he placed himself in the situation, or whether it was just wrong place, wrong time. I don't really know the details.
So you weren't very close to him, so this isn't something that you would carry into the jury room. Okay. Number 27, I'm gonna come back to you on that. You had two family members that were murdered.
Family member and a very close friend.
Okay. How long ago was that?
I thought the odd was 17, but it was actually closer to 20 years ago.
And your friend?
6 years ago.
You still think about him?
Yes, my close friend, very much so. I was a lot younger from my aunt, but we were close. But my friend, we were actually best friends.
Sorry.
Yeah.
Obviously, my client is charged with murder. And so you could anticipate that I'd be concerned that your experience with your friend and your aunt could impact how you feel in this case. When the state asked you about that, you said, I don't think it will bleed over. You don't think that it'll influence you. I don't think is kind of equivocal.
Yeah, being candid and honest at that point, because I can't say right away that, it just absolutely won't. But I don't carry that bias into the courtroom. I will get the evidence of the case and make a decision based on evidence.
But as you sit here, you can't say to me, Mr. Zellman, I'm not going to think about that at all.
Yeah, I'm not sure.
Okay, thank you.
I'm sorry, you said it would be not true?
Yeah, that'd be.
Now, and you've heard the state say this a few times, and we probably addressed it when we were back in individual voir dire. the court's instruction is going to be that you can only rely on the evidence that's presented in court. But as you sit here, you can't tell me that I'm not going to think about that.
No, I can say that I would absolutely rely on evidence of the case. When you were asking about thinking about the past cases of mine, past incidents of mine, our best friend, and just as a human being, as the case goes on, if I saw pictures or images or something, I may have a thought about those two.
And that actually brings up a good point, sir. This is a murder case. There are going to be pictures from the crime scene, from the medical examiner. For those new prospective jurors, are you comfortable having to see some of those pictures in this case? Is anyone uncomfortable? If I can get a show of hands. Not that we like having to do this, but is anyone uncomfortable? No hands. Thank you. I'm going to go through briefly some of the hypotheticals that I used to discuss the burden of proof. It's beyond a reasonable doubt. Did everyone hear the bank robbery hypothetical that I addressed earlier? Yes. Okay. Number 33. So with that hypothetical, the first one, where the witnesses to the bank robbery identify the defendant, the surveillance video depicts the defendant, and the defense attorney gets up in closing argument and says, "The state didn't prove it wasn't my client's twin brother." What kind of doubt is that creating or raising? You remember what we discussed earlier? What was discussed earlier with the prior panel?
Yeah.
What kind of doubt did we discuss? Anyone else remember? Number 27.
Speculative.
And speculative doubt is not what?
Not reasonable.
Has anyone ever had a knee-jerk reaction?
Yes.
Jump to conclusions? Okay, I'm going to pick on number 30. You ever jump to a conclusion before?
Yes.
You realize that you were wrong?
Yes.
In that moment, did you say something that you may have regretted?
Yes, I did.
You realized that you were wrong.
Yes.
Everyone else have similar circumstances happen?
Yes.
Just a moment, Your Honor. Number 32, you indicated earlier that you had a family member who's retired law enforcement?
Yes, sir.
And who is that?
My husband's uncle is retired with Leon County Sheriff's Department and
I'm sorry.
and also worked for the governor.
Okay. You close with that individual?
Yes.
Do you hold is their opinion of you important? to you?
Sure, yes.
Okay. Now, would you have any concern if you were selected as a juror in this case, heard all the evidence, and returned a verdict of not guilty, how your husband's uncle would feel?
No.
Okay, thank you. Same question for number 34. No concern?
No concern.
It's your husband.
It's my husband. No concern at all.
Number 14? No, 20. Sorry, 29. Yeah, my numbers are all messed up. You had friends or family in law enforcement?
Brother-in-law works for FDLE. He's Capitol Police. And I know a few, at least one who's mine are retired law enforcement.
Any concern about what they would think of you if you found somebody not guilty?
That's right.
Even of murder?
Correct. No, sir.
Thank you. Number 27, you had,
Yeah, it's several friends. But they several friends, they all went back in Sarasota County.
okay.
But no concern.
You're not concerned?
No.
Okay. Anyone else have their hand or paddle raised to law enforcement? Did we talk to you about that? Well, we can't talk to you about it again, so. But specific as to the new people, sorry. As to the new people, anyone been divorced? No divorces for the new people? Good for you. I haven't been so lucky. Let's see. For the new people, this, as I said earlier for the prior panel, it's not something I would normally ask, and I apologize if it's offensive in any way. But just for those new people, can I see a raise of hands of anyone who has any knowledge of Judaism? There's certain events in our culture that are important in life events, correct?
Yes.
Can you give us some examples?
Referring to Judaism specifically?
Yes.
Bar mitzvahs is what comes to mind.
Bar mitzvah being
Or a bat mitzvah for
Yeah.
girls. Yeah.
okay. Thank you. Anyone else familiar with Judaism? Number 35. How do you feel about some call them jailhouse informants or jailhouse snitches? How do you feel about them?
I can't say that I have an opinion.
You can't say you have an opinion?
Opinion about them,
Okay.
or I haven't formulated an opinion.
Okay. Why do you think that somebody would, a jailhouse informant or a snitch would testify against somebody? What would motivate them?
I don't know. Maybe they want to do the right thing, or maybe they get a quid pro quo out of it. They get something.
They get something in return?
Yeah, possibly like a lighter sentence, or I don't know. Maybe they get like I don't know, more benefits.
I'm sorry?
More benefits in jail. I don't know.
So, do you judge their testimony more critically as because they're getting a benefit?
Not necessarily.
Number 28. How do you feel about that?
I don't have an opinion on it, really.
The fact that they might be getting a benefit, is that something that you would consider in weighing their credibility?
I think I'd be more cautious in listening to what they present.
Does everyone agree with what number 28 said? Be more cautious in what they say?
Yes.
Anyone in the new group disagree with that? Ma'am, do you disagree with that? Yes.
I would
No?
also be more cautious.
I can't hear you.
I would also be cautious.
Okay.
For the one.
Thank you.
Good use of your paddle.
Just a moment, Your Honor.